Hello and welcome to Liberty Nation's LNTV. I'm your host, Mark Angelides. Now, Trump's had a big win at the Supreme Court this week. It's the case of the Department of Homeland Security versus New York. And here to help us unravel what happened is Liberty Nation's legal affairs editor, Mr. Scott DeCrescenzo. Welcome, Scott.
Hi, Mark.
So, Scott, what happened?
Okay, well, what happened was that the Trump administration has tried to enforce some immigration rules that have been long on the federal legal books. This all stems from the Immigration Act of 1952, I believe, as amended. And what it does is it provides that immigration officers should, in fact, discriminate against applicants who are likely to need public assistance if they are allowed to be or remain in the United States. And it encourages them and directs them not to grant those people that immigration status. So the Trump administration says, here's this rule, we're actually going to enforce this rule. And they publish in the Federal Register a rulemaking guide for federal officials to be commensurate with this law. Everybody freaks out and says it's going to be used for nefarious purposes. Democrats, especially Attorney General activist Democrats, say, for instance, they allege it's going to be used for racially discriminatory purposes. I will say, absent any, it seems like I can discover any evidence to that effect. But in any case, a number of federal judges offered injunctions or issued injunctions against the enforcement of this law, one of which in New York issued a nationwide injunction. The Trump administration went to court and said, please lift this injunction while we fight over the merits of the case. So forgetting about whether or not we should win or lose the case in chief, let's at least let us continue to use these factors as we go forward. What happened is the Supreme Court said that the injunction was inappropriately granted in a 5-4 vote, and that while the case is being fought out in the lower courts, the Trump administration can continue to discriminate against people who may be on public assistance in immigration matters.
So, I mean, what did the dissenters say on this? I'm assuming it's fairly obvious who the dissenters were on this particular issue. But what did they say?
This was not an opinion, as we call a Supreme Court opinion, where there's a case briefed and then there are arguments before the court and then the court issues an opinion. There's usually a majority opinion or unanimous opinion and then a minority opinion. That's not what happened here. What happened here was this was an application by the Trump administration to the court for basically emergency relief or urgent relief from the stay.
Injunctive relief on the injunction.
It was a 5-4 ruling, but typically these types of orders, which is how we describe this, does not include an opinion at all. So you ask what the minority said, and it was Alito, Roberts, Thomas, Kavanaugh, and Gorsuch for the majority, and Ginsburg, Breyer, Sotomayor, and Kagan in the minority. Very traditional, left-right split on the court. But Justice Gorsuch did a very odd thing, which is that he took his pen to write a multi-page decision excoriating the lower court for the injunction itself and for the rash of nationwide injunctions that the lower courts have seen fit to issue in the Trump era.
That actually brings me on to my question here, Scott. When you have a lower court issuing a nationwide injunction, surely this is just asking to waste time, because it's bound to end up in a higher level court at some point. Isn't that right?
When I tell you that Justice Gorsuch went off on the lower court, I mean he went off, Mark, and Justice Thomas signed on to his opinion. So he feels the same way, which is yes. And Justice Gorsuch actually laid out all the reasons why it's bad lawmaking. In other words, the traditional method is for the district courts to have a kind of very sober analysis of fact finding and gather all the facts, take testimony, then that decision is made, then it goes before the courts of appeals. The courts of appeals sometimes, when they make a decision, they actually ask the lower courts for more facts, which is to say, to improve the record for them to make their judgment. And then they make their writing, and then it goes to the Supreme Court. And also, it only concerns the actual litigants. So, if there's one person who lives in Yemen who's been discriminated against because of one provision of the immigration law, traditionally would be for them to go ahead and sue, and maybe the ruling would apply to people similarly situated to themselves, but not every single person on the earth just because they're a human, which is what we've seen. Again, this is a phenomenon that we've seen with Trump. And Justice Gorsuch has had enough of it, and so has Justice Thomas.
Now, you mentioned just now this is a phenomenon we've seen with President Trump. Is it something that took place at all prior to President Trump? For example, in the Obama or Clinton or Bush administrations?
There's no like national database of nationwide injunctions that I can go to consult for that. It certainly has happened in the past, but to say it is,
it's almost the automatic go-to position now for
that may be just a bit rich, but the frequency and prevalence of these orders, Mark, is off the charts, geometrically increased in the Trump era. And again, the decision lays out why that is all bad news for all the litigants. It makes bad law. The system is not set up for everybody to run around with emergency orders and emergency responses, and then back and forth orders and responses again.
Yeah, I mean, clearly there's going to be a lot more happening in this case as it goes forward. But what is next for the case?
Mark, the case will return back to the district court, where they will try the case, not an hearing on an emergency matter, but actually go ahead and delve into the facts and discover whether or not it seems like it's unconstitutional or not, and then a ruling will issue from that court. If I were a betting man, I would say the Second Circuit Court of Appeals will then hear an appeal from whoever the losing party is in that case. And then we can see, no matter who wins or loses in the Second Circuit Court of Appeals, they will almost certainly appeal to the United States Supreme Court, who will then either let that lower court judgment stand or take the case to hear it and then issue their own ruling, again, on the facts and not on the urgent or emergency basis hearing on the injunction.
That's a very interesting case, Scott. Thanks for elucidating for us. Much appreciated.
Thank you, Mark.
And thanks to you at home for watching.
Hi, folks. Lisa K. Donner here, editor-in-chief of LibertyNation.com. We hope you enjoyed watching this video, maybe even learned a thing or two. If so, please take a moment and subscribe to our YouTube channel right down there in the corner. Thanks so much.